Carol Williams with Williams Immigration, and we are here for another Monday morning edition of Beyond the Soundbite, where we talk about all things U.S. immigration. So, you know me, I like to dive right in. The first thing I want to talk about are the visa bulletin is out and it has been announced and posted on the Department of State website for the month of July. And one of the more significant things that we are seeing is a backlog for Indian nationals in the EB3 category. So if you're wondering what all that means, what I just said, let me give you a really high level explanation. So the Visa Bulletin is a chart that is released by the Department of State every single month. And it essentially tells us which green card applications can be processed not only by the consulates overseas, but also by USCIS here in the United States. So if you're working with a consulate, it tells you who can finally be scheduled for their final interview. And if you're working with USCIS, it tells us who can file their adjustment of status application. And if that application has already been filed with USCIS, it allows USCIS to really start working on it and hopefully get it approved for you in that month. Now, the Visa Bulletin, I said, comes out every single month. So the dates in the Visa Bulletin change each month. The Visa Bulletin, it's a chart with countries and the visa categories, and there is a date in each box. That date represents the day that you started your green card application, that the first application in connection with your green card application was received by the US government. So that date changes each month, and that date represents a place in line. So that place in line, you can think of it as the pipeline of the cases that are already pending with either the Immigration Service or the consulates. So there is a very complicated formula that the Department of State uses to move those dates forwards and backwards. So when the dates move backwards or when they retrogress, it means that it's going to take someone longer to get a green card. When those dates move forward, it means it is quicker for someone to get their green card. So that's kind of the very super high level explanation of the Visa Bulletin. So for the July Visa Bulletin, individuals from India who are in the EB3 category, in their dates have retrogressed, meaning their dates have gone backwards. So in June, the June Visa Bulletin, the EB3 priority date was June 15th of 2012. Now for the July Visa Bulletin, their priority date is now January 1, 2009. So that priority date has retrogressed several years, which now means that as of July 1, so it's beginning in July 1 and only for the month of July, individuals who are Indian nationals from India and who have filed an EB3 green card application, they are only eligible to either one, have the consulate begin working on their application, or two, file their adjustment of status with USCIS if their priority date, and that is the day they first filed with the US government for their green card, if their priority date is before January 1, 2009. So as you can see, that's a very long time frame. So everyone who filed January 1, 2009 and later is currently not eligible to either one, reach out to the consulate and have them schedule an interview for them, or two, file their adjustment of status with USCIS. Or three, if they were in fact eligible quite some time ago to file their adjustment of status and they have done that, USCIS is not able to start working on that application as of July of this year. So if you need to discuss how the Visa Bulletin and the priority dates impact your employees' work authorization, their ability to get their green card, and your ability to keep them employed as their employer, please feel free to call our office. We are more than happy to set up a consultation with you and have that conversation. And we can be reached at 954 903-1337. The next thing I want to talk about, I feel like you guys already know what it's going to be. It's the H-1B cap cases. We are heading into the final stretch of H-1B cap season. Those applications that were selected during the lottery are due to the Immigration Service by June 30th of this year. So that date is coming up quickly. So just keep that in mind. I know my colleagues and I, we are working to get those last applications filed with the Immigration Service. So again, if you were selected in the cap, if you were selected in the lottery as part of this year's cap, that H-1B application is due to USCIS no later than June 30th. The next thing I want to talk to y'all about are USCIS increase in fees. That proposed rule is still out there. USCIS has been pretty quiet about it, which leads me to believe they are still working on it, but it has not gone away. So if you are on the fence about filing for an immigration benefit, if you are on the fence about applying for citizenship, applying for a green card, now is the time to do it before those fees go up, because when those fees go up, you will not be able to take advantage of the current filing fees, okay? So just be aware that that has not gone by the wayside. Immigration is probably still just tweaking that final rule. The next topic of discussion for us this morning is the I-9s. So all throughout COVID, beginning in March of 2020, ICE, Immigration and Customs Enforcement, who oversees the I-9 form, has said we can, as employers, look at documents that support the I-9 virtually because of the pandemic. Normally, all of those supporting documents need to be looked at in person, and then you sign off on the I-9 indicating that you have looked at the actual physical document. So obviously, because of social distancing and COVID, ICE came out and said, we get it, but you still need to complete your I-9, you just complete them virtually. Now they have said that was always going to be temporary. They were always very clear about that. So the date in which these COVID-19 virtual looking at documents and the COVID flexibilities, that ends July 31st of this year. So at the end of next month, that's it. No more looking at I-9 documents virtually. They are giving employers until August 30th of this year, so 1 month past the end of the flexibilities, to go back and look at all of those I-9 documents in person that you previously looked at virtually, and update your I-9s. So for some, for larger companies, that may be a fairly significant project. For some of our smaller companies, that may not be, as time intensive. Either way, the COVID flexibilities for our I-9s and remote review of those documents ends next month, July 31st. And then by August 30th of this year, you must have updated all of your I-9s for all those individuals where you looked at their documents virtually. I am predicting that we will see an uptick in the number of I-9 audits, spot audits, random audits, just to make sure that businesses are complying with basically going back to looking at documents in person. So if you are unclear how you can go about this, if you're unclear what your process should be, if you're unclear how to fill out your I-9s, feel free to reach out to our office. We can set up a consultation for you. 954-903-1337. And just keep in mind that your I-9 verification is super important. It tells you the identity and the work authorization ability of the person that you have hired. So very, very important things. We want to make sure that you are filling out the form correctly and that you are fully in compliance. Next thing I want to talk with y'all about this morning is the Florida Senate Bill, SB 1718. It was passed. It goes into effect goes into effect next month, July 1st. So July 1st of 2023. It is a Florida-specific bill. So it is not for the entire country. This is only for Florida. So it's Florida Senate Bill SB 1718. It's got a few things in it. I want to highlight a few of them so that my employers in Florida know what they can expect and what they should be preparing for. Employers with 25 or more employees now in Florida, beginning July 1st, are now going to be mandated to use E-Verify. E-Verify is a federally owned and operated program. It helps employers verify the work authorization of their employees. The difference between E-Verify and the I-9 is that E-Verify pings off of Social Security Administration and the Department of State databases to confirm work authorization. The I-9 does not do that. The I-9 relies on the employer to receive documents from the employee, look at those documents, fill out the form, and then file those forms appropriately within the office. E-Verify goes one step further and is a fully electronic process that pings again from Social Security Administration as well as Department of Homeland Security. If there is something like a Social Security number that is punched into the system that doesn't match the associated name that is also punched into the system, Social Security and DHS will notify the employer, and then the employer will need to have the conversation with the employee. So E-Verify goes one step further than the I-9 process. So Florida Senate Bill 1718, as of July 1, will require all employers with 25 or more employees to use E-Verify to confirm work authorization of their employees. As a result of this, I, again, fully suspect that we're going to be seeing more audits, more I-9 audits, more E-Verify audits in the state of Florida as a result of this new rule. So that's just my own personal prediction. We'll see what happens. I will, of course, keep you updated. The other thing to note about Florida Senate Bill 1718 is that it prevents the recognition within the state of Florida of driver's licenses that were issued by other states to individuals that are undocumented in the United States. So this rule essentially says that the state of Florida is not going to accept validly or driver's licenses that were issued to individuals who are undocumented by other states. So even though the driver's license in another state was issued and it was correctly issued because those are those own states' laws, Florida has said as of July 1st, we will no longer accept and recognize those driver's licenses from other states if they were issued to someone who is not in status here in the United States. So just keep that in mind. The rule also requires hospitals and healthcare systems to collect and report statistics on the immigration status of patients. Currently, hospitals and healthcare systems are really not asking those questions. They are focusing on the treatment of their patients. This bill, SB 1718, now is requiring another layer that they must do in data that they must collect and then report out on. So I will keep you updated on SB 1718 as we get closer to it becoming effective, which will be July 1st of this year, and we'll see what happens. The last thing I want to talk to you all about is I want to give you another tip on National Interest Waiver. So as you know, National Interest Waiver is a green card category here in the United States. It is an employment-based green card category. In order to qualify, you must be working in or have a proposed endeavor that has both substantial merit and national importance. You must also show as the individual that you are well positioned to advance this proposed endeavor. So not only do you have a great idea, not only are you doing very well in your industry, not only are you showing substantial merit and national importance, you've got to show that you can continue that level of work and that level of impact after the green card is issued. So that on balance, the third prong is that it would be beneficial for the country, for the United States, to waive the normal requirements of having a job offer, which means having an employer sponsor you, and recruiting for the particular position, meaning putting out advertising for qualified US citizens. So those are the three things that we need to show for a national interest waiver application. The tip I have for you today is that individuals can what we call self-sponsor, meaning they do not need to have an employer to sponsor their national interest waiver. They still need to meet all of the criteria. So they still need to be working in a proposed endeavor that has substantial merit and can show national importance, and that they are well positioned once they obtain the green card to continue in this endeavor. So those are two major pieces of the puzzle. So it's not just that you can apply on your own, it's that you can apply on your own and still meet the qualifications. So for national interest waiver, you do not need an employer to sponsor you. And if that is something that you want to see if you qualify for or talk about, feel free to reach out to our office, 954-903-1337, and we are happy to get you set up for a consultation and talk about that. This is all I have this morning for our Monday morning edition of Beyond the Soundbite. If you have any questions about your immigration cases, you need help hiring someone who is not a U.S. citizen after you've identified that candidate, or you've gone online and there's so much information you're just not quite sure what's accurate, what's not accurate about how to sponsor an employee to come work for you, or they're already working for you and you're not quite sure how or when you should start their green card application, feel free to reach out to my office. We're happy to get you set up with a consultation and get you on the right path. I am Carol Williams. This has been another Monday morning edition of Beyond the Soundbite. Have a great Monday morning.